Hello and welcome to this video. I hope you're doing well. Today we will be talking about drafting a composite suit with respect to infringement of intellectual property, specifically with respect to counterfeit of goods. Something that, all of us have come across at one point or the other, in the sense that, everybody has seen counterfeit goods, copies of very popular, be it shoes or bags or apparels, being sold by somebody who actually is not authorized to do so. These are basically fakes or dupes of original products, right? This mostly happens in cases of the product being very, very popular. And the appearance of the product being so popular that people would just be willing to buy it on the basis of its appearance. So that is what is essentially copied when counterfeit goods are made. Not just the trademark of the brand is used, but the exact design is also copied, which basically attracts a few of the IP laws. So we will be talking about how would one draft a composite IP suit. Not just that, we'll try and understand how we can do that through AI, right? So I have Bard over here, and I gave some specific prompts to Bard. Firstly, I asked it to draft a plaint seeking relief against the sale of counterfeit goods in India. These goods infringe the rights of my client under the trademark and design laws. These are the two laws that I specifically mentioned. Please let me know what information you need from me. And then Bard got back to me with these requirements. Right, I was asked to provide these details, such as the client's information, what is the specific information as far as the trademark is concerned, right? So the registration details of my trademark, the design information, the registration details of my design, right? The defendant's information, what are the damages being caused, and what are the reliefs that I seek out of such a suit, right? All of this was required to be provided by me. So I copied all this information and then provided the relevant information against the relevant head, right? So I provide the client's name, the defendant's name, their addresses, all of that. Then, description of counterfeit goods. So I specified over here that the counterfeit goods are in exact replica of the plaintiff's highly popular clutch bag that has a unique print, which is a house code of the brand and is engraved with the brand's popular logo. The print is a registered design. Additionally, the print has been established as a source identifier of the brand, thereby acting as a trademark. Very important. What I'm doing over here is I'm claiming that my client has design rights with respect to the print which is on the bag, right? It is a registered design. In addition to it, I'm also saying that this print acts as a source identifier for my client, which means that this has essentially become a trademark as well, right? So the laws of passing off could be invoked over here, right? Location of sale. So this is all happening on e-commerce websites. That is what I have spoke about over here. The bag is very well known to the general public and is solely associated with the plaintiff. The defendant is selling an identical looking bag to the public with the intention to ride upon the immense goodwill that the plaintiff has created in relation to the bag over the years, right? The sale of the identical looking bag by the defendant has been causing excessive loss to the goodwill and reputation of the plaintiff, as the plaintiff has no control over the manufacture of these bags and cannot vouch for the quality of these products, right? If a very popular product is being sold not by the authorized representative, but by somebody that the plaintiff does not have control over, then the plaintiff cannot really say what is the kind of quality of goods that are being sold. And remember, these goods are very popular as far as the plaintiff is concerned, the plaintiff's identity is attached to those goods. So if those goods are going to be of a bad quality, that will, a lot of people may perceive these goods to be actually coming from the plaintiff, right? They won't perceive them to be as fakes sometimes, and that would directly threaten the goodwill that the plaintiff has created, right? Owing to the fact that the defendant is selling these bags at exactly the same price point as the plaintiff, the consumers will not be able to ascertain that these bags are in fact unauthorized copies of the plaintiff's original products, right? So this is also something that I've stated, because a lot of times this defense can be taken that these products are being sold at a very cheap price. So there's something called, consumer sophistication. This is a term that we use for trademark, which means that a product, if is being sold at a very cheap price in comparison to the original product, then there is no scope of confusion, because anybody who's buying that product will know that this is not actually coming from the original brand, right? So to do away with that, I have over here stated that these are actually being sold at the same price point, which again makes it further more difficult for anybody buying these products to understand that they are not coming from the original source, right? So that is something that I have provided. I provided all this information, and then this is the plaint that was given to me by Bard on the basis of the information that I provided, right? Now it reads like this. We'll read the specifics of it in a few minutes, but this is how it looked. And I mean, it was, I felt that it was way too short, right? And I definitely felt that we could provide more information to Bart so that it could incorporate that information to make the plaint more descriptive. So I asked it to incorporate certain changes. Firstly, I asked it to remove headings because this does not look like the correct way a plaint would be drafted. So I just, asked it to remove the paragraphs to begin with. We could add it later if we want. So that's something that I've asked. Some additional information with respect to the plaintiff is as follows. So I provided some additional information with respect to the plaintiff because I need them I basically, whoever is reading it, I would need to get the impression across that this particular brand is very, very popular, so that I can establish the fact that yes, the defendant would have the intention to actually copy something that the plaintiff owns, right? So in all IP related cases, it's very important to establish that the plaintiff has that kind of a reputation in the market, which would be enviable, or which, people trust a lot. So I provided this additional information. The brand was founded in 1946, so very, very old brand. And Marilyn Monroe, Elizabeth Taylor, Grace Kelly were just some of the stars seen in HR creations. HR is the brand, is the plaintiff. Many of its garments are hand sewn, and every detail is carefully considered. HR pieces are often considered investments. Many other pieces have become collector's items and have been sold at auctions for high sums. The brand is synonymous with luxury, elegance, and taste. Its history and influence of the world of fashion are undeniable, right? So all this information. Then further, always we have to remember that trademarks are territorial in nature. So even if we talk about the fact that the brand has such a global image, it is very popular brand, we have to bring it back home. We will have to basically talk about India and how it is something which has a certain kind of a reputation in India as well, right? Otherwise, this question will arise that, what about India? What about the fact that, what is the kind of reputation that it has in India? Or does it have any kind of reputation or usage in India, right? So we have to talk about India as well. To strengthen its commercial ties in India, the plaintiff has entered into an exclusive multi-store retail and e-commerce license agreement with leading Indian retail chain to operate its stores and e-commerce website and sell goods including its ready-made clothing and footwear and all of that. So that is something that I've talked about. Talk about the global trademark and design registrations that the plaintiff has, along with Indian registration. So like I said, territorial rights have to be established when we talk about intellectual property, but talking about your global IP enforcement always helps. So that is something that you should always include. State that the defendant has been selling bags identical to the popular Lady HR bags through various e-commerce stores in India. Emphasize extensively on the scope of confusion in the minds of the public with respect to the counterfeit bag of the defendant. Scope of confusion is a term which is very important when we talk about infringement of intellectual property, especially for trademarks or for anything wherein we are claiming that there is this particular product or this aspect has become a source of identification for the brand, right? So this is something which we have to emphasize extensively upon, that there is a scope of confusion, which means that people are bound to get confused. There is a very good probability, there is a very good chance that people are going to get confused when they look at these fake products, these counterfeit products. They are going to think that yes, they belong to the original brand which has created these products, right? Talk about how the defendant's act outrightly constitutes as trademark infringement. Passing off of the plaintiff's extremely popular bag, which acts as a source identifier, thereby invoking passing off. And design infringement, right? Design infringement is something that we can only claim when the design is registered, right? So we have already talked about the fact that this is a registered design, that too in India, right? So on the basis of these additional prompts that I gave, this is what I got, but I just wanted it to be a little more detailed, right? So I received a more detailed version, right? Of course, after having received a more detailed version, I would still have to make certain changes to the final plaint. That goes without saying, right? But Bard has made my job significantly easier now. I have a template. I have more than a template. In fact, I have a very good structure, and there's certain information that I can fill within the same, which I have done, which I will just show you over here. So I've just copied whatever Bard provided to me, and then in red, I have just specified the changes that I've had to make, right? So firstly, like I was talking about headings. So I have made changes to the headings because I did not like the headings that Bard provided us. So the heading, for instance, was Plaintiff, a legacy of exquisite craftsmanship and global recognition. Rather than that, I decided to keep it plain and simple by just stating that this is the background of the plaintiff, right? And then the language was good that that Bard had used. I'll just read some of it. Founded in 1946 by the visionary French designer Harry Ford, Harry Ford Inc. has carved a unique niche in the world of luxury fashion. Throughout its illustrious history, HR has consistently adhered to uncompromising standards of craftsmanship, utilizing the finest materials and meticulous attention to detail in each creation. This unwavering dedication to quality and innovation has garnered HR a global reputation for timeless elegance and sophisticated design. Right, so the language is very prim and proper, which is how it should be when you're drafting a plaint, right? And then again, plaintiff's presence in India, that is something that absolutely you have to talk about, like I just stated. So again, the heading has been changed by me and certain pointers have been added. The plaintiff has been present in Indian market since 1994 when it opened its first flagship store in Bombay. The arrival of the plaintiff brand in India made several headlines owing to the fact that it was one of the very first global luxury fashion houses to open a store in India. Since then, the plaintiff has invested substantial resources towards its Indian market, and in return has had India as one of its most profitable markets, right? And then certain elements have been other elements also have been added by me, like the revenues. Firstly, the amount that plaintiff has spent towards advertising. This is something again that you have to show. Whenever we are talking about, whenever we are talking about reputation, we should directly also talk about the kind of advertisements that we have made, the amounts that we have spent towards advertisement, right? So that is something that you can talk about every year, how much of investment was made as far as advertisement was concerned. So what was your advertising expenditure? Then, very important, how much money did you make? What were your revenues year on year? That is again something which is very, very important that you should provide, because that again, if you are a very profitable company, it automatically means that you have essentially attained a lot of reputation and goodwill in the market. If a lot of people are buying your products, it means that a lot of people are actually understanding where you're coming from. They know you, right? So that's that. So that these are the additional pointers that I've added. Otherwise, this all was provided to me by Bard. Exclusive multi-store retail and e-commerce license agreements have been entered into. So that's something that has been done. Extensive retail network since this year. HR has opened 18 brick and mortar retail stores across various major Indian cities. These stores provide a curated selection of genuine HR products, including handbags like the lady HR bag, right? So that's that. Plaintiff writes in the infringed design. So now we have talked about the brand, the reputation that it has built, all of that. Now we are coming on to the infringement subject matter, right? So the infringed design is what we are going to be talking about. The bag of the plaintiff, counterfeit copies of which are being sold by the defendant, is a highly popular and sought after commodity, popularly known as the Lady HR. The bag got this name due to its long and continuous association with Lady Diana, the Princess of Wales, who was photographed at various occasions adorning this particular bag. The bag has emerged as one of the brand's most iconic and cherished creations. Its captivating design and enduring quality have earned it a place of distinction in the world of luxury handbags. Why are we saying all of this? This is very, very important, because we have to establish the fact that people, when they see this bag, they think of the plaintiff. This is what your aim has to be. So you have to really extensively talk about how popular this bag is, right? So I have just added this information that this bag has its own name, right? So that's something, and there's a history behind it. There is a very popular person who was associated with this bag. So it automatically will mean that this bag is very sought after, this bag is very popular, and it's a very natural thing that somebody will wish to have such popularity with respect to their product, right? So that's that. Then I've talked about the fact that it's a registered design. The specific pattern that the bag has on it, it's a registered design. That's something that Bart stated, but a very important aspect that I had to talk about over here was passing off, right? So this is what I have stated. In addition to being protected under the design laws, the color combination, because of its extensive use by the brand across its multiple products, has become an apparent source of identification for the brand. The pattern is so closely associated with the brand that the use of it anywhere without a doubt indicates an association with the brand. Therefore, it is safe to say that the print has gone on to act as a trademark for the brand, thereby being protected under the laws of passing off, right? So trademark is being infringed, we know that. Design is being infringed, we know that. And we have also talked about now passing off, right? And then over here, we are talking about the fact that there is a global trademark protection with respect to the brand's name, right? So that's that. Then we've moved on to what is it that the defendant is doing. So basically the fact that the defendant is selling this bag on various e-commerce platforms. That is what we have talked about over here. As you can see, I have only added certain statements, but mostly what Bard has provided is correct. Legal claims also, what Bard has provided is correct. Trademark infringement, passing off, and design infringement. Cause of action. So basically this information is something that you will have to add yourself. When exactly did the cause of action arise? You have to speak to your client, you have to add that information. Jurisdiction also, it's better if you do this yourself. You see which would be the correct jurisdiction, and then you justify it, right? So that is what has been provided over here by me. What are the reliefs sought? This was again Bard. And prayer. So prayer also I had specified in the initial information that Bard had asked me. I had specified that this is the these are the specific reliefs that I seek out of here, and this is what has been provided to me by Bard, that I am seeking a permanent injunction with respect to the sale of the goods, delivery up of any of the infringing goods that the plaintiff the defendant possesses, damages, what exactly can I seek as far as monetary compensation is concerned, and any other relief that the honorable court may deem fit. And there is a verification clause at the end of every plaint, so that is also something that I have provided it. But as you can see that more than 50% of my work, in fact, was done by Bard. And because of the help of Bard, I was actually able to do this particular, make this particular draft within a significantly lesser time, right? All right, so this is it for this video. I hope this was useful. Thank you.